Welcome to Realty Talk, where we talk real about real estate. My name is Frank Rodriguez, and our goal is to bring you transparent and useful information relating to real estate. Welcome back. Yes, this is Frank here at Casa Bella Realty Group. I'm excited. And even though we're speaking of a topic that is not all that great to speak about, as I mentioned before in our video 1, which, by the way, if you haven't watched, I recommend you go back to watch it so you can get in sync with the remaining series that we're doing here, which is probates, right? Today's our second video. And, it happens to be that, this topic, even though it's not exciting to speak about, it's needed. It's needed, and I'm not sure if you can see my cup here, right? I'm going to be a grandpa for the first time, and as I think of my legacy right now with having a grandchild, it hits me more than ever, right? On a very personal level, that it's not about only the next generation. We have to think forward, right? Second, third, fourth generation. And doing this for over 30 years, I've been involved with many of families relating to probate, and it always hurts me that they're going through so much, and it's the first generation, and usually because things weren't done properly, they stop. And whoever the deceased person was, I mean, we've had grandparents, we've had parents, aunts, uncles, I mean, you name it. And they moved on, they passed on, and because of not speaking to professionals, not watching videos like this where you can not only hear information, but you can gain or hear from experience and knowledge, right, that you can apply. They passed on, and they left a mess. And it always saddens me as a professional, because it kind of, the whole legacy thing stopped. It stopped. They gave it their all. They lived their life, and because they didn't do something correctly, or didn't understand, or didn't get the necessary guidance, their legacy ended, right? Other than name or what have you. But so I'm excited to be speaking of this topic, and also applying in my life now that I'm going to be a grandpa, right? Making sure that my future generations are taken care of, and I can be a good role model for them to continue doing what I'm going to do. Okay, so thank you for taking the time to be here. And from the first video, we discussed the complexities of probate. And through these complexities, the potential pitfalls, challenges, and from the last video to today, during the interim, we've had a lot of questions, comments that, if probate is so complex, why is it need, or not so much why it's needed, because we covered that, but how can we avoid it? How can we avoid it? So I decided to discuss that today. I'm going to discuss it, the two main methods that are used primarily, right? And there's a few others. Okay, and these two methods, one is adding a beneficiary on title, and the second method is creating a living trust. So let's go more in detail what these two methods are and some of the pros and cons. Okay, the first method, adding beneficiaries or heirs on title, it's, I believe, something that's rampant in our industry, because we have real estate agents, we have notaries, we have paralegals that advise clients with maybe not the best information. And I believe their hearts are in the right place, because it is effective. It will avoid probate, though it's not the best way to do it. And the reason is this, is when someone is added on title, and the way this is done is by having a grant deed drawn up, and let's say in this case the surviving parent or parents add their children or children on title as joint tenants, meaning it gives the children right of survivorship, that when the parent passes away, the property goes automatically to those remaining joint tenants without having to go through probate. So it is effective. It is effective, and I believe this is why a lot of this is done. Though the negative part of this is that when that happens, the children, once they're added on title as joint tenants, they're pretty much receiving the current tax basis, which later on can have a big impact on what we call capital gains. I won't go into too much detail in this video about that, though know that the current tax basis for that property is in essence transferred or adopted by the joint tenant, and it sticks. Okay, and there will be some tax consequences along with that down the line. Okay, the second method that's not as commonly used, though is effective and it's the better option, is a living trust. And for this, the surviving parent or parents create a living trust. I recommend you hire a legal professional to create one for you. Now, once it's created, a lot of the documents that are in there, including a will, you name what's called a successor trustee. And when the person that created the living trust is the trustee of it, meaning that the property is owned by the trust, though the trustee controls the trust, okay, which is very powerful. So it's when that person passes away, the trustee, the person that created the trust, then the properties and any other instructions, belongings managed through the trust are transferred to whoever, right, the beneficiaries are, including the successor trustee, without going through probate. Now, the benefit of this is at that moment when the surviving parent, the trustee, or both parents pass away, then the tax basis that they had on these properties is increased to the moment they pass away, meaning there's a step-up basis, which again, on a separate video, I'll go more into that. Though just know this for now, having that step-up basis is going to benefit the heirs with capital gains. Maybe eliminate it altogether, right? Now, there's some other drawbacks, especially on the first one, adding people on title beneficiaries. One is the parents lose control. They lose control of the property. And there's been times, and there was a story not too long ago in a newspaper where a child was added on title, and the child started doing things with the property, and unbeknownst to the parent, somehow they were able to get the parent to go along with certain paperwork, though the property was lost. So it's not always the best thing for that, because a parent wants to maintain control, right? As long as they're of sound mind, they should maintain control. So when you add children or other people on title, you're losing some control. So that's another drawback from the first option. So I highly recommend the second option. Again, it's not as commonly used because there's additional costs and more work to be done as far as paperwork and having to think how you want your future generations, your legacy, right, to survive you, right, as far as what you're creating. So those are the two. Okay, now how to initiate a probate. That's something else that I was asked about is, okay, someone passes away, and if from the first video we watched, when someone passes away with a will, meaning they took the time to write a will. In this case, again, we're not speaking of living trust anymore. I mean, this is actually going to go to probate, meaning that the person that passed away, the property was in their personal name. Okay, in their personal name, they pass away, and let's say they died with a will. There's a person naming that will as the person that's going to execute the wishes of the person that created the will. That's why we call this person the executor. Okay, so once the person passes away that creates the will, that owns the properties, be it a parent, an aunt, uncle, then the executor doesn't have to, though I highly recommend hire a probate attorney, and the probate attorney will start the filing of a petition at the county courthouse that handles the probates. And at this moment, that petition is filed, and the reason for the petition is to confirm and validate the will and confirm the petitioner, in this case the executor, as the executor. And the time frame from filing the petition to being in front of the judge to confirm the petition, it's anywhere between 3 weeks to a month and a half on the high end, right? So we're looking at 3 to 6 weeks. Okay, now up until that point, the estate is pretty much in limbo, because even though there's a will, the executor can't do anything really other than, look out for the best interest by keeping an eye on properties and any personal belongings, and keeping the rest of the beneficiaries or heirs, calm until they're named confirmed as the we commonly know it as the personal representative. In this case, will be the executor, the personal representative. Once they're confirmed at the hearing, that's when they could start doing whatever's needed to be done on behalf of the estate and the other beneficiaries and heirs. Okay, so that's how to initiate it from the standpoint of having a will in the estate and someone being named as the executor. Now, the big question is this, and if you're watching this video, maybe you want to ask yourself this question: do you have a will? Do you own property? And if the answer is no, and if someone passes away, they own properties, and there's no will, then we know the legal jargon is intestate. The person passes away intestate, no will, then it changes a bit. There's a little bit more chaos possibly among family members, and one family member, or excuse me, let me rephrase that. It doesn't have to be a family member. By the way, on the first option, the executor doesn't have to be an heir. It could be anyone, right? On this one here, there's a hierarchy that's followed depending on the state that you're in. In California, there's a hierarchy. It's not based on who's the oldest child. Sometimes we run into families that, they have a parent that passed away intestate, and, the eldest child believes that they're in charge. And that's not the case. It's not about the age, right? So among themselves, they have to decide who's going to petition the court to be named the administrator. And this is when someone passes away without a will, to administer the estate. Now, same process, someone passes away, in this case without a will, the family members have a conversation, and they decide on either one of the siblings, an uncle, someone else, someone that's more responsible, organized, clean record. It's a must in case they need to get a bond, and preferably good credit, so the bond, does not so much affect it as far as the cost. And then once the family decides who's going to be the administrator, then with the attorney, which again I recommend, that person will file that petition at the courthouse. And same timeline, 3 to 6 weeks to go before the judge. If there's no one contesting that this person administers the estate, then usually they're confirmed as the administrator. And at that point, they can start doing what's needed for the estate on behalf of the estate with any real estate, personal belongings, securing everything, and take it from there. Okay, I think for this video, this is enough. We covered the 2 main ways that are used to avoid probate, and we also covered how to initiate a probate with or without a will. Hope you enjoyed it.